I woke up as the best friend who betrays the heroine in chapter 30 and is never mentioned again. The comments were already calling me a snake, 11 chapters before I was written to do anything. I arrived in the middle of a document review, which is the least cinematic place a person has ever been dropped into in the history of this genre, and I want that on the record. Not a ballroom, not an altar, a windowless room on the 14th floor of a building in the financial district, with 11 paralegals at 11 laptops, tagging documents, responsive or non-responsive, for 11 hours a day, and a whiteboard with a target on it, and somebody's abandoned salad. I came to with my hand on a mouse and a highlighter behind my ear, and a woman 4 seats down saying, "Marguerite, Marg, are you going to eat that?" And over her head, in the air, in pale letters nobody else could see, here she is, the snake. I cannot believe Sabra trusts her. 11 chapters until chapter 30, and I am going to be sick. I want to explain what it is like to read the word snake in the air above a colleague's head when you are 47 years old and have never in your life been called anything worse than firm. It is not frightening. It is insulting, and the insult is what got me moving, because I had read the book. I read it on the train, on my phone, 4 stops each way, for about 6 weeks. It is called Fiduciary, and it is about a young associate called Sabra Innes, who takes on a case her firm does not want her to take. And it is not bad. It is genuinely not bad. And I remember thinking on the 0742 that the betrayal in chapter 30 was the weakest thing in it, because the friend does it for money, and the money is never explained, and afterwards she just stops existing. 4 pages. That is what the whole of Marguerite Pell gets. 4 pages in chapter 30, where she sells a privileged document to the other side for a sum the author does not name, and then a line in chapter 34 where somebody says she has left the firm, and then nothing, for 200 more pages, forever. And now I was her, in her body, at her desk, 11 chapters early, with a highlighter behind my ear. My name is Gerry Vance. I am 47, and I sat on a stenotype machine in courtrooms for 22 years, and if you want to know what I felt in that first 90 seconds, it was not fear, and it was not wonder. It was the specific professional irritation of a person who has spent 2 decades getting things down exactly right, being told by 400,000 strangers what she was about to do. I sat on a machine for 22 years. Nobody understands what that job is, including most of the lawyers I did it for, so here is the part that matters. A stenographer does not type words. You write phonetically, in chords, 20-odd keys pressed in combinations, and a competent one runs at 220 words a minute for hours, and what you develop is not speed exactly, it is a way of holding language that has nothing to do with meaning. You take a sentence in whole and put it down whole, and because you are not processing it for sense, you do not smooth it. You get the ums, you get the false starts, the half word somebody swallowed, the 4-second pause before an answer, the exact place a man says actually. And if you do that for 22 years, 8 hours a day, something happens to your memory that nobody has ever properly measured, which is that you become able to hold an unremarkable conversation entire, in its own words, for weeks, not a superpower. Callous, I could not tell you my own bank card number, and I can tell you what a judge in Sacramento said to a man about a drainage easement in 2011, with the ums in it. 3 things from the 22 years, so you know what kind of woman was standing in that stairwell. I took a murder trial in 2009 where the defendant's mother testified for 6 hours, and I did not smooth 1 word of her, and defense counsel used 4 of my readbacks in closing, and afterwards he shook my hand and could not remember my name. And I want to be clear that this did not bother me even slightly, and that this is the whole personality of a court reporter. I have been in rooms where a man's life turned on whether he said I would or I could, and I am the reason anybody knows which. And in 2018, I took a deposition where a partner at a very large firm said something to a witness during a break, with the machine still running because I had not been told to go off the record. And he came back in and asked me to strike it. And I said I could not. And he said, "Nobody will ever look at this." And I said, "Then it costs you nothing to leave it in." And he looked at me for about 4 seconds. That is the only time in 22 years I said anything clever out loud to a lawyer, and I have dined on it for the rest of my life. And here is what that is worth in the world I had landed in. Nothing, initially, because Marguerite Pell is a paralegal on a document review, and nobody asks a paralegal anything. So for the first 3 weeks, I did what I would advise anybody in an impossible position to do, which is that I did the job. I tagged documents. I was fast because verbatim training makes you fast at reading too, and by the end of week 2, I was clearing about 400 a day against a team average of 260. And Bex Tallow, the senior associate who ran that room and who is the loud one in this story, came and stood behind me on a Thursday and said, "What are you doing?" I said, "Reviewing." She said, "Nobody does 400. You're not reading them." And I said, "Document 41186, the third attachment." The second paragraph says the meeting was moved to the Tuesday at the request of the client's brother, and the brother isn't on the privilege log, and if he was in the meeting, then 11 of the documents you've had tagged privileged since March are not privileged. The comments went off like an alarm. What? What? Marg does not know that. This is not in the book. Why does the snake know about privilege? Chapter 30 is 4 pages long, and I read them about 40 times in my head over 11 weeks because it was the only intelligence I had. Here is what it actually says, stripped of the prose. Marguerite Pell meets a man in a car park. She hands over a copy of a memorandum that is subject to legal privilege and that would destroy Sabra Innes's case if the other side had it. She is paid. The man is described as being from Aldous Brandt, which is the firm on the other side. Sabra finds out in Chapter 32 from an anonymous email and confronts her, and Marguerite says a single line, which is, "You have never once had to think about money," and then she is gone. That is it. And the thing that had been bothering me on the 0742, weeks before any of this, is the thing that saved me. It does not make sense. Not emotionally, procedurally, because Aldous Brandt cannot use that memorandum. A privileged document that arrives in the hands of opposing counsel is not a weapon. It is a live grenade. Counsel who receives obviously privileged material is obliged to stop reading, notify, and sequester it, and if they use it, they get disqualified from the case and reported, and every lawyer alive knows this. No competent firm buys a privileged memo from a paralegal in a car park. It is the single stupidest thing a law firm could do. So either the author had not thought about it, which is possible and which is what I assumed on the train, or the man in the car park was not from Aldous Brandt. And once I had that, I had a question worth 11 weeks, and the question was not, how do I avoid Chapter 30? It was who benefits from that memorandum being in the wrong hands, and the answer is nobody on the other side, and the answer is somebody who wants Sabra Innes's case to collapse for a reason that has nothing to do with winning it. Which is when I stopped trying to protect myself and started doing the only thing my previous life had actually equipped me to do, which is to sit very still in rooms and get down exactly what people say. He took me into the East Stairwell in March. Hollis Rooke has been managing partner since 2014. He is 62. He has the kind of quiet that people describe as gravitas until it is described in a transcript, and he had spoken to Marguerite Pell twice in 4 years, both times about a fire drill. And on the 11th of March, at 6:10 in the evening, he came into the review room, which managing partners do not do, and said, "Miss Pell, could I borrow you?" and took me out to the East Stairwell, which is the one with no camera because it opens onto the loading level, and talked to me for 11 minutes. And I want to describe what that 11 minutes actually was because it was masterly and because nothing in it was a crime. He asked about my mother. He knew about my mother, which meant he had asked somebody. He said he had noticed the review numbers and that people notice, and that he had come up the same way, and that the difference between a paralegal and an associate in this firm was one person deciding to take an interest. He said that Sabra Innes was extremely talented and extremely young, and that the Kessel file was going to break her, and that everybody could see it except her, and that the kindest outcome for that young woman was for the case to end quickly. He said that things sometimes find their way to the other side, and that when they do, nobody looks very hard, because nobody wants to. He said the words, "If it happened, it would be a kindness." He did not offer me money. He did not name a document. He never once said anything that could be put in front of a bar committee, and I stood in that stairwell and understood that the man was building the 4 pages in front of me from the inside, and that in the version of this story 400,000 people had read, it had worked, and that in that version I had gone to a car park and taken money from a man who was not from Aldous Brandt and had never been asked a single question about it, and had left the firm, and had been called a snake for 200 pages, and I wrote it down, not on paper. I sat in that stairwell after he left, for about 20 minutes, on the concrete step, and I ran the 11 minutes back and set it, the way you set a hearing you were not permitted to record, with the ums in it, 4 times through until it was fixed, which is a thing I had done perhaps 300 times in 22 years, for judges who wanted a read back, and technology that had failed. The comments, who had been calling me a snake for 3 months, said one thing that night, and then went very quiet. Wait, why is Rooke talking to her? Hollis Rooke has been managing partner since 2014, and the reason he needed the Kessel case to die is the least glamorous motive available, and it is the true one. Kessel is a class of 1,100 delivery drivers, claiming they were misclassified as contractors, and Sabra Innes had it on contingency, and the firm's exposure if it lost was manageable, and its exposure if it won was not, because the defendant is a logistics group, and that logistics group's parent is the firm's second largest client by billings, and had been since 2016. Through a different subsidiary and a different relationship partner, and the relationship partner was Rooke, he had a conflict. Not a technical one, a real one. And the conflict had been checked and cleared in 2022 by the firm's own conflicts committee on a form Rooke had filled in himself, and the form omits the parent. That is the whole crime, and it is one blank box on an internal form, and it is the reason a man spent 2 years quietly steering a case toward a collapse he could not be seen to arrange. I nearly went to the Bar Association in April, on my own, with nothing. I had drafted the letter and I had the envelope, and what stopped me was 22 years of watching what happens to an uncorroborated account given by a junior person about a senior one. I have taken those hearings, I have sat on a machine and written down, verbatim, a 26-year-old assistant describing a thing that happened to her, accurately, in order, with the ums in it, and then written down 4 senior people saying they had no recollection of that, and then written down the finding, which was insufficient evidence, and then packed up my machine and gone home. 3 times. The words are identical every time, and I could give you all 3 from memory, and I am not going to. So I knew, in a way that nobody else in that building could have known, exactly what my 11 minutes was worth in April, which was nothing, and exactly what it would be worth if it were ever given under oath in a proceeding somebody else had started for a reason of their own, which was everything. That is not patience. Patience is a virtue, and this was a technical assessment of the value of testimony, and it is the only genuinely useful thing I brought with me out of a life spent in the corner of other people's disasters. And I found the form the way you find anything in a law firm, which is by asking a person who has worked there longer than the partners. Her name is Laureen, and she has run the file room since 1997, and she is the single most powerful individual in that building, and no one has ever noticed. I did not ask her for a document. I asked her a question, which is a different thing, and the question was whether she remembered the Kessel conflicts check, and Laureen said, which one? And I said, there was more than one, and Laureen said, there's always more than one, love. There's the one they file, and there's the one they do first. He moved on me in May, and it was the promotion, which I had been stupid enough to enjoy for about 9 days. In April, Rooke had me made a senior review coordinator, out of that windowless room and onto the 14th floor, with a pass that opened the file room and a seat at the Kessel case meetings, and everybody congratulated me, and Sibra bought me a plant. And what that actually was, which took me until May to see, is that a paralegal who leaks a privileged memo is a scandal, and a senior review coordinator with unsupervised access to the privilege log who leaks a privileged memo is a criminal, and he had spent 2 months upgrading the crime he was going to have me commit. Then in May he did the second thing, which was that he asked me, in a case meeting, in front of 6 people, to take custody of the master privilege set. Sole custody, because of my excellent numbers, and I sat there and understood that when the memorandum went out of that building, the log would show exactly 1 person had held it, and that I would be looking at 11 felony counts rather than a firing, and that in the version 400,000 people had read, this is the part where Marguerite Pell had felt flattered. So I said no. In the meeting, out loud, which nobody in that firm had ever done to that man, and I said it with a reason that could not be argued with, which is that sole custody of a privilege set by a non-lawyer is a bad idea in a case that already has a privilege dispute, and that it should sit with an associate. Rooke smiled and said that was very sensible. And that evening he sent me an email, warm 3 lines, saying he admired the instinct and that we should get lunch, and I have that email, and it is nothing, and it is the only piece of paper he ever gave me, and I kept it for 2 years like a tooth. Meanwhile, I had a heroine problem, which nobody in the comments ever understood, and which was the hardest part of the whole 11 weeks. Sabre Ennis is genuinely good. She is 29, and she works until 11, and she remembers the drivers' names, and she cannot be told anything, because she is the protagonist, and the protagonist of a legal drama is constitutionally incapable of believing that the managing partner who has been kind to her is the problem. I tried twice. The first time she thought I was gossiping. The second time, in April, she said, gently, in the corridor by the printers, "Marg, I know things have been hard at home," which is a sentence I have heard used on 11 different women in 11 different depositions. And I stood by a printer and understood that being the friend in this story means being the person whose warnings are read as symptoms. That was so sad. Sabra is trying so hard to be nice to her. And the awful thing, the thing I have not got over, is that she was not being condescending. She was being kind. She had been told by somebody that Marguerite Pell's mother was ill, and she had gone away and thought about how to be gentle about it. Rooke had told her. Of course he had told her. He had spent 2 years building a version of me in that building the way you build a case, out of true small pieces, so that when Chapter 30 arrived, nobody would need convincing. Thank you for listening to Channel Crystal Novel. The deposition was on a Thursday in a room with no windows in the June, and it was not my deposition. That is the part that made it work, and it is the part I would want anybody to take from this. I did not blow anything up. I did not stand in an atrium. There was no atrium. What happened is that Aldous Brandt, defending, noticed something they were entitled to notice, which is that 11 documents on our privilege log had been logged as privileged on a basis that had changed in March, and they moved to compel, and the court ordered a limited deposition of the person responsible for the privilege review and the person responsible for the privilege review. By then, because I had been promoted out of that room in April by a managing partner who wanted me close, was me. So on a Thursday in June, I sat at the end of a table in a room with no windows, with a court reporter on my left, a woman of about 60 on a machine, and I want to say that I looked at that machine for a moment longer than I should have. Aldous Brandt's partner took me through the log, competently and without malice, for about 90 minutes, and then he asked the question that everybody in that room thought was housekeeping, which is whether I had ever discussed the Kessel Privilege Review with anyone outside the case team. And I said yes. He said with whom? I said with Hollis Rooke on the 11th of March at approximately 6:10 in the evening in the east stairwell of the 14th floor for approximately 11 minutes. And our own firm's defending counsel said, I'm going to instruct the witness not to answer on privilege. And Aldous Brandt said that a communication in a stairwell between a managing partner with no role on the file and a paralegal was not privileged, and he would take it to the magistrate at 11 the next morning. And the magistrate heard it and ordered the answer, and we came back on the Friday, and I sat down at the end of the table, and Aldous Brandt said, Ms. Pell, to the best of your recollection, what did Mr. Rooke say to you? And I gave it to them. 11 minutes, verbatim, with the ums in it, with the 4-second pause after he said the word kindness, and I said the pause out loud. I said, and then he did not say anything for about 4 seconds, because that is what you do in a readback. It took 19 minutes because I gave it at dictation pace for the reporter, and about 6 minutes in, she stopped looking at her machine, which a reporter does not do, and I said, sorry, too fast, and she said no, and then, after a second, you've done this, and I said, a long time ago. No exhibit, no folder, no document, no recording, nothing to authenticate and nothing to suppress. And by the time I finished, the thing itself existed, because a deposition transcript is a document, and I had just made one out of a conversation a man had deliberately had in the one stairwell with no camera. Our own defending counsel objected 11 times during those 19 minutes, on form, on foundation, on speculation, and on one occasion simply said objection with nothing after it, which is in the transcript, and each objection went on to the record, and none of them stopped me, because an objection at a deposition does not stop a witness answering. It only preserves the point for later, and every lawyer in that room knew it, and one of them had clearly forgotten. At about minute 14, he said, Ms. Pell, you cannot possibly be recalling this verbatim. And I said that it was a trained skill and not a claim about my character, and that he was welcome to test it. And he said how, and I said, ask the reporter to read back the first 90 seconds of my answer, and I will give you the next 90 without hearing it. He did not take that up. It was the single most enjoyable moment of my second life, and I have replayed it more than I should. Our own counsel asked for a recess. Aldous Brandt's partner said, I don't think we need one, and that is the single most enjoyable sentence I have ever heard a lawyer say. The referral went out in June, and the machinery took 2 years, which is what it always takes, and which nobody in a novel ever waits for. Hollis Rooke was placed on leave the following Monday, resigned in the August, was disbarred in the second year on findings of conflict of interest, failure to disclose, and conduct prejudicial to the administration of justice, and pleaded to 1 federal count in the third, and the sentence was 14 months. The firm paid $4.1 million to settle the malpractice exposure to its own clients, lost the logistics parent as a client anyway, and dissolved its Chicago office. The conflicts form went to the state bar as a systemic complaint as well as a personal one, and the outcome nobody reported is the one that matters. 211 firms in that state now require the conflicts check to be run against the ultimate parent and not the contracting entity, because the bar issued an ethics opinion in the third year that cites the Kessel discovery record, and that is one query in a database, and it would have caught Rooke in 2022 in about 9 seconds. Aldous Brandt's partner, whose name is Emeka Oduya, and who I had spent 11 weeks regarding as the enemy because a novel told me to, wrote to the firm afterwards to say that, in his view, the witness had conducted herself properly, which he did not have to do, and which went into my file. Bex Tallow, who bullied that review room for 2 years and who was not part of any of it, was interviewed 9 times and cleared, and left the law entirely and teaches now, and I have complicated feelings about that. Lorene still runs the file room. She was never interviewed by anybody, because nobody ever thinks of the file room, and she has never once mentioned any of it to me except in the 2nd year when she put a cup of tea on my desk and said, "The one they do first," and walked off. And Kessel was tried in the 3rd year, and the class won, and 1,100 drivers were reclassified with back contributions, and the decision runs to 91 pages. And on page 14, in a footnote about the privilege dispute that shaped the discovery schedule, there is a sentence naming the paralegal whose testimony resolved it, Marguerite Pell. In a reported decision, in a footnote, which is where the actual history of the law lives, and which is going to be read by law students for 30 years by people who will have no idea that in another version of this, she sold a memo in a car park for a sum nobody bothered to name and stopped existing on page 411. Sabra Innes made partner in the 4th year. She is the same. She still cannot be told anything, and she remembers the drivers' names, and she asked me once, at the party after the verdict, why I had kept trying to warn her when she had been so patronizing about it, and I said, because you were right about the case. And she said, that's not an answer, and I said, it's the only one that's any of your business, and she laughed for about a minute. I am a paralegal, not an associate, not a lawyer. I did not go to law school in the back half of this and become anybody's idea of a success. I run the review teams now, all of them, and I have 11 people, and the first thing I tell every single one of them on their first morning is that the most valuable thing in this building is not a document, it is an accurate account of a conversation, and that if a partner ever takes them somewhere without a camera, they should sit down afterwards, alone, for 20 minutes, and put it down whole with the ums in it, and never tell anybody they have. 4 of them have. 2 of those were nothing, and the comments stopped in the 2nd year, gradually the way a crowd leaves a room, and the last one I saw was during the verdict coverage, and whoever wrote it had clearly gone back and reread the whole thing from the start, and it said, I have been calling her a snake since chapter 19, and she had not done anything yet. So here is what I want to know from you, since you have been reading over my shoulder, and in this particular case, I know exactly what that is like. Did she go far enough, or was she still too merciful? Comment justice if the ending was perfect. Comment harder if you wanted an even colder revenge. Your comments decide how ruthless the next ending should be. Like and subscribe if you want to be here for the next end.